All rise.
Oops.
Thank you. Thank you.
You've done Lord Brown's homework. I hope it gave you some chance for refreshment as well.
Yes, I'm sorry it's in manuscript. We'll send it in a typed version after court. Can I just read it through quickly?
Yeah.
That'd be easier. The offender is sentenced to 2 4-year terms for offences committed before and after the commencement date 4th of April 2005. Paragraph 25 makes clear that Section 264, brought into force by Para 19 of Schedule 1 and not disapplied by any provision of Schedule 2, applies to combine the two sentences. However, it applies in a modified way, which must refer to the position of parolable prisoners, those serving 4 years or more, for whom automatic release is at the 2/3 point, Section 33(2). Therefore, this offender is only subject to automatic release having served half of one 4-year term and 2/3 of the other. The discretionary wording reflects the fact that the Secretary of State may release the offender at the halfway point of the 1991 Act sentence under Section 35. Now, we say that that must be the reason for paragraph 25. If the sentences were less than 4 years, it wouldn't make any difference. But because the 1991 Act had a different regime for sentences of 4 years or more, the offender, having committed this offence before the commencement of the 2003 Act, would gain an unwarranted advantage unless Section 264 was applied in a modified way, because they would get a non-parolable sentence with entitlement to release at halfway rather than a parolable sentence. What this paragraph, we say, doesn't mean is that it only applies where there's an extended sentence, because there's no mention at all of extended sentences, and we can't, for our part, fathom why paragraph 25 would apply to extended sentences under the previous regime. So I hope that that's helpful. Can I go back to the Court of Appeal decision, and we'd come to a natural part of the judgment to break at, because the court, partially based on what we say is a flawed view of paragraphs 19 and 25, ended up with the conclusion that paragraph 14 was to be construed as the Secretary of State had submitted, but then went on to deal with the policy issue, because if the Secretary of State is right and that these sentences have to be dealt with distinctly, then how is it that the two sets of sentences are to be combined? Now, up to shortly before the Court of Appeal's consideration, the Secretary of State's position, set out at 45 of the Court of Appeal judgment, was that this lacuna should be filled by the policy that was set out in Ms Seddon's witness statement in the Highton case. The Secretary of State amended their position by saying that in fact it wasn't a policy to fill the lacuna, it was just an explanation of the way that the provisions should work. And with the greatest respect to the Secretary of State, we say that that's not right. It isn't possible to combine these two mechanisms unless there is some process by which that is done, and that has always been done and remains the position that it's done by a statutory mechanism. But at 49, the Court of Appeal accepted the argument of the Secretary of State that on true analysis, the approach taken by the Secretary of State, which has been described as a matter of policy, is not in reality a matter of policy at all, but follows from the sentence passed by the court read with the statutory provisions. This, he submits, is not merely a rational policy. More importunately, it is...
I think he might be an important bit.
Yes. I'm sorry, yes. More importantly, thank you, it is the outcome dictated by applying the statutory provisions to the sentences passed. And then importantly, we say at 50, for my part, absent any power confirmed by Parliament, I would regard it as objectionable in a democratic society for the Secretary of State to dictate by policy matters such as eligibility for release on licence or the period of time spent on licence and liable to recall. In short, I do not think the Secretary of State has the power to make a policy statement of this kind. Now, I'll return to this point, but we say that's a very important part of this judgment because it asserts that if there is a lacuna, that it can't be filled by the Secretary of State coming up with some
There's no appeal against that.
policy to do it.
There's no appeal against that, is there?
No.
It's not.
No, there isn't. Indeed. And then the court goes on to say that the purported statement of policy is no more than an accurate reflection of the manner in which the legislation operates. Well, with the greatest respect to the Court of Appeal and the Secretary of State, we take issue with that. If there is a lacuna, it can't be filled with a policy or with some explanation as how these two separate, distinct processes or mechanisms work together, which has hitherto and remains being part of a statutory mechanism. From 51, the court then goes on to accept the Secretary of State's reasoning in what was hitherto described as the policy. Picking up at 51, my reasoning is as follows. When a judge passes consecutive sentences, it is inevitable that one sentence follows the other. As Ms Seddon explained in the witness statement and the senior presiding judge mentioned in his note, the first sentence handed down should be treated as the lead sentence, and eligibility for HDC will be determined by reference to the last sentence served. Well, our submission on that is a very straightforward one. Why should that be the approach? There is no justification in the provisions, we say, at all for identifying a lead sentence, or indeed for applying HDC to the last sentence and not to the others. Quite the contrary. The court then goes on, it seems to me inevitable that when passing consecutive sentences, the judge will identify which is the sentence to be served first, the lead sentence. And then the court goes through the way that the judge would express the sentence in a consecutive sentence case.
So the illustration, you will go to prison for 6 months on each of counts 1 and 2 concurrently in those sentences. Which is first of those two?
Um, 18 months would be the first sentence.
Because it said that the first ones are going to be consecutive to the second.
Yes. Plainly, that is the way that consecutive sentences are passed. We take no issue about that. That in the normal, but not invariable run of cases, the judge will identify the main sentence, usually the longest, and then will make other sentences consecutive to that. I say it's not invariable because there are cases, and the case which we referred to, the case of Dunn, was a case where the shortest sentence was passed first, simply because it was chronologically the first that was committed. So different judges will pass consecutive sentences in different ways, but the usual way that one sees it in practice is that the longer sentence, generally for the more serious offence, is passed first, and then the shorter sentences are passed consecutive to that. But the point that we raise on this is that there is no reason to identify a lead sentence for the purposes of sentence calculation, and we're not able to point to any other area of sentence calculation where the order of sentences matters at all. This is the only position where it appears that it's being said that the order of sentences matters.
On the whole, the more important question is what the total sentence should be.
Yes. Generally, the approach, as we saw this morning with the combining provisions, going back historically, is that the totality is worked out, either under the 1991 Act or the 2003 Act, and then the early release provisions are applied to that. And therefore we say that this just doesn't follow. This process of identifying a lead sentence and only applying HDC to the last sentence served doesn't apply. The court continues at section 52 to follow the Secretary of State's submission that what the judge is doing in setting a consecutive sentence under section 154 is to set a sentence which is not to take effect from the day on which it is imposed. Entirely, we respectfully entirely agree with that. And then at 53, assuming the judge has said no more than that, one sentence is to be consecutive to another, it is necessary to construe in a common sense way what section 154 direction the judge is to be taken to have given as to when the second sentence should commence. It seems to me obvious that the second sentence starts at the point at which release from the first sentence would otherwise occur as a right, i.e. the conditional release date of the first sentence. The other theoretical options are unrealistic. Well, our submission here, going back to what I said at the outset of my submissions on the provisions, is that one has to start from the point of view of separating the provisions which go to jurisdiction for consecutive sentences and the provisions which deal with how sentences are to be calculated. And I have no difficulty with the suggestion that the judge is saying in a consecutive sentence, obviously, that sentence 2 is to follow sentence 1. But I do not, with the greatest respect, agree with the proposition that it's obvious that the second sentence starts at the point at which release from the first sentence would otherwise occur.
What, if that were the position, what would there be to stop a prisoner 153 days? Let us suppose 153 days before the halfway period of the first long sentence, saying, I'm now eligible to be released on
135
licence.
days.
135.
135
Yes.
days, sorry. Please release me on licence. The second sentence isn't due to begin until the halfway stage, and I'm entirely entitled to have my licence application considered.
Well, that's entirely our approach, that Parliament has created this statutory discretionary early release provision.
Yes.
If the Secretary of State is right that you have to consider these cases with the two sets of sentences separately,
yes,
then each is subject to that statutory discretionary early release scheme. And the approach taken by the Secretary of State and adopted by the Court of Appeal is simply to ignore that statutory discretion in respect to the first of the sentences. And we say that that can't be done.
But it would also infringe what is elsewhere deliberately precluded, the principle that you don't move in and out of prison. I think we saw a provision to the effect that you can't impose a consecutive sentence.
Section 265.
Yes, that's right.
Yes. Well, it would, but the effect of combining the sentences is that you have one HDC eligibility under the statutory provisions.
Yes.
The effect of the Secretary of State's submissions adopted by the Court of Appeal is that you have two sets of HDC eligibility, but you ignore the first.
Yes. Well, what is there a warrant for doing that?
There isn't. That, with respect, my Lord, has our submission on that point.
Furthermore, if you impose the longer sentences first, the effect is likely to be to curtail the scope for your early release, isn't it? Because it's proportionate to the final sentence.
I'm sorry, I didn't quite follow that.
Well, if you have two sentences which have got to be dealt with differently, one for 5 years and one for 5 months,
Yes.
and you can't have regard to the 5 years when you're deciding when you're going to release the defendant.
Yes.
It's going to act to his detriment if you're not aggregating the lot.
Well, in fact, it could work in both ways in respect to that example, because on the Secretary of State's view adopted by the Court of Appeal, there would be an HDC eligibility on the second term, on the 5 months, which there wouldn't be under
But
our.
what would it be?
It would be on the 5 months.
Yes, but that wouldn't be.
It would be a quarter of the
Yes,
5
it wouldn't be
months.
100. That's the point
No,
I'm
no,
making, is
absolutely
that it
not.
reduces the
No.
scope.
Indeed.
Because it's proportionate to the sentence.
Yes,
And if the final sentence is the smallest, or the smaller,
which it almost always
which
is.
it almost always is,
Yes.
the point you're making.
Yes. The case of Dunn was an unusual case.
Yes, but one would have thought that was actually contrary to the overall policy,
Yes.
which would, I can't see any reason why it shouldn't
Well,
be a policy of letting people out proportionate to the aggregate of the
yes,
sentence.
we say the policy is the policy doesn't change because the 2003 Act HDC, with the few differences that we looked at this morning, reenacts the 1991 Act provisions. So the policy is to release prisoners 135 days prior to release if they're serving 18 months or more in less than 4 years, subject to the risk assessment, etc. Indeed. But the more fundamental objection in our submission to this approach to starting the second sentence at the automatic release date of the first sentence is that you convert the consecutive sentence into a concurrent sentence. What happens is that the second sentence, if it's a short sentence, is entirely subsumed into the first sentence, and therefore it simply isn't a consecutive sentence. It may be partly consecutive, but it's turned into a concurrent sentence. So, with the greatest respect to the Court of Appeal, it's not common sense, we say, to simply start the second set of sentences at the automatic release date for the first set of sentences.
You use the expression automatic. I mean, for this purpose, is that the same as conditional release date?
Yes.
It's automatic conditional.
Yes.
I see.
Yes, I'm simply drawing a distinction between a discretionary early release and
Right.
HDC. Now, it may well be that that's the way it operates in practice, that the combining provisions aggregate the custodial periods, so that the custodial period of the second sentence does in practice start at the automatic conditional release date of the first, but only if it's subject to the combining provisions, which combine the licence periods as well as the custodial periods. In that case, you've single-termed or aggregated the different sentences, the custodial periods and the licence periods, and you've applied the early release provisions properly, so they are properly consecutive sentences. But on this solution, you're merely starting sentence 2 halfway through sentence 1, and therefore we say it's objectionable in principle that it isn't a consecutive sentence once you do that. The final thing about the judgment, or the final 2 points that I seek to make about the Court of Appeal judgment, is that in fact, having determined that the Secretary of State's approach is loyal to the order in which the sentencing judge passes the sentences, the Secretary of State perfectly properly points out that in fact that isn't always the case, and that whereas the method approved by the Court of Appeal is to identify the lead sentence, the approach taken by the Court of Appeal is then not necessarily to follow the order that the sentences are passed. Now,
Because the lead sentence would attract any other sentences passed under the same regime. And
precisely.
Yeah.
And can I just illustrate that by one of our examples, which is example 4 at page 33 of our case. Example 3. The prisoner sentenced to 12 months plus 6 months plus 12 months. What in fact the Court of Appeal approach is that the first sentence is 12 months is the lead sentence, but then the last sentence isn't the second 12-month sentence, because that is combined with the first 12-month sentence, and the 6-month sentence is then becomes the last sentence. So, although it's loyal to the first sentence passed by the judge, it then isn't loyal to the order in which the judge passes the other sentences. And so, in our submission, it begins to unravel on that point. But the appellant's approach and the approach under both of the Parent Acts, it doesn't matter what order these sentences are passed. Either under the 1991 Act or under the 2003 Act, 2 consecutive sentences of, say, 12 and 6 months. It doesn't matter whether the judge expresses that as 12 plus 6 or 6 plus 12. One reaches exactly the same result in terms of both automatic release and HDC. So this is the only scenario which is created, we say, whereby the order of sentence makes any difference. Finally, just a point I just want to come back to in a moment, but as we have the page open, can I just refer to paragraph 60 of Lord Justice Wall's concurring judgment, where he approves the lower court's sympathy with the despair that the judge felt when considering the statutory provisions in this case, and the view that he expressed that it's simply unacceptable in a society governed by the rule of law for it to be well nigh impossible to discern from statutory provisions what a sentence means in practice.
Is section 174 disapplied in respect of under 12-month sentences?
Every sentence.
I would think that the judges would like it to be disapplied in that respect.
Section 174, I think, applies to every sentence, including conditional discharge.
So the judges, in fact, under this solution, have to explain both limbs, so to speak.
Yes. Well, it would depend. To be fair, it would depend how far one took the duty under section 174. Whether the judge has to explain how HDC works. I don't think I would argue that the judge has to explain how eligibility to HDC works.
You could argue that section 174 is frequently not complied with.
Yes.
Because the judge says, almost always, that means you'll serve half the sentence in custody, then you'll be released, and then you'll be on licence.
Yes.
He's no idea, and can't have.
No.
Detention curfew will be, or any other provisions that may suddenly emerge.
No. Well, with respect, I agree.
Is he supposed to explain eligibility for home detention curfew or not?
Well, my submission would be not.
Well, I think you could argue that the Act requires that he should, but the reality is that it doesn't happen.
Yes. Well, I think I'd like to argue that it should, but it would be virtually impossible, because the sentencing exercise is so complicated that for the judge to have to work through the sort of exercise that we've been looking at for the whole of this morning.
Well, no, all he has to do is to explain the effect. So assume that the Court of Appeal's judgment stands. I mean, there it is. Your examples indicate what the consequence of that is.
Yes.
And at what point eligibility arises. Would he not be required to explain that? Why not?
I'd be very surprised. Because he would have to understand precisely how much time had been spent on remand and this sort of thing, wouldn't he?
Well, the remand period,
is that all known?
the judge has to deal with that under section 240 of the Act in any event. Prior to the 2003 Act, remand time was dealt with by the custodian.
Yes,
and
but the judge actually has to...
The 2003 Act has now brought in a process where the judge has to be told the number of days, has to order whether they apply or not to the sentence.
That's because an order is needed.
That's because an order is needed, indeed, yes. It would be extremely difficult for a judge to explain to a sentenced prisoner much about HDC because it's also discretionary and there are policy objectives. So it could only go so far as explaining eligibility. It couldn't go any further than that.
No,
But the judge would have to be alive to the statutory exceptions, for example. It would be a very difficult exercise for a judge to...
But Section 174 hasn't yet had to be the subject of judicial expatiation. Has it or not?
In respect of...
Well, just what it involves.
Not so far as I... Well, my learned friend reminds me in the case of Round and Dunn,
I see.
in December of last year, the court held that that the sentencing judge should not have regard in passing the sentence to early release schemes, including HDC.
Point.
But that is a different point. Yes, indeed. Yes.
You're supposed to explain the effect of the sentence. If judges started giving particular dates, there'll be a very severe risk that they get it wrong. And what would be the effect then? Would there be some expectation that you're going to be let out early?
They do, and there is, so far as time to count is concerned, but there's now an easier way of remedying the situation than there used to be.
In that there is now a written process for rectifying errors, and in fact there's now also a longer slip rule provision so that the Crown Court can also rectify problems of that nature. But going back to where I started this morning, I pointed out that in the cases that we've referred to in respect of this particular problem, including this one, they've almost all come to light as a result of the prison administration not being able to work out the HDC eligibility. And therefore for it to be taken back one step to sentencing judges who aren't engaged generally with working out how the extent of prison sentences, I would venture to say would be virtually impossible. And I think it would be a brave submission to submit that under Section 174 judges are required to tell a prisoner about when they were eligible.
Does anyone know what the judge actually said in his or her sentencing remarks in this case?
The Secretary of State has got them. I've read them, and my recollection is that nothing was said about HDC. I'll be corrected if I'm wrong.
We've got the order made and the transcript.
But I'll be corrected if I'm wrong, but I don't think HDC was mentioned by the judge. Yeah. That concludes my submissions in respect of the provisions themselves and the and the Court of Appeal decision.
I think this is just one.
Oh, there's one of them. Okay.
That's the Chief Justice, isn't it? It's just a single bundle of everything. Then there are 5 copies on it.
Is it one bundle or 5 bundles?
We seem to have got different bundles, each containing one of something. Is that what?
Well, if you hand them back, I'll sort it out. It's very short. Shall I read what it said? I've come to the conclusion that the right sentence of the matter on the indictment after the trial was on 24 months imprisonment. There's a reference to mitigation. With respect to the committal for sentence, the sentences will be one of 4 months imprisonment, bearing in mind the guilty. Will be concurrent with each other, consecutive to the 22 months. That makes a total of 26 months. In addition, I have to deal with you for contempt, where you failed to attend court for a muting hearing. There will be 1 month consecutive, making a total of 27 months. You will serve up to half the sentence I've imposed upon you. Upon your release, you'll be unlicensed until the end of the sentence. I formally have to caution you that if you commit any further offence or breach your licence during the currency of that licence period, you can be returned to prison. That is a matter for the authorities rather than me. And then there's just mentioned the days on remand.
But is it right that he's on licence till the end of his sentence on the Court of Appeal's approach?
No.
Right?
No, that isn't
You
correct.
tack on the 5 months at the end
Yes.
and there isn't any licence.
Yes, precisely. The effect of the Court of Appeal decision is that the licence ends 5 months before the sentence ends.
Well, therefore, it's wrong what he says here
Yes.
at 7D to E.
Under the appellant's solution, the licence does run to the sentence expiry date, so
Yeah.
the judge
So
would,
that is incorrect.
well, the judge would be right if the appellant's right. Can I move on to ambiguity? And I think I can move a little more swiftly with my submissions because they're more of broad principle in many regards now. Our position on paragraph 14 is that it is ambiguous, and I've addressed you to some extent on that. And we deal with it in a little more detail at paragraph 24 of the printed case, where we set out what Mrs. Justice Dobbs indicated about ambiguity, and in fact a little more of what Mr. Justice Mitting said at first instance in this case, and the reference, for example, to the legislation of this obscurity. In round and done at paragraph 5, maybe just convenient to go to that. It's at divider 26. It's at the bottom of the paragraph 5, in a somewhat understated sentence, it is perhaps unnecessary to say that the effect of that provision is not immediately apparent to the reader. And so it seems that the courts that have dealt in some detail with this provision have differed slightly about their approach to it, but they seem to have accepted hitherto that this is an ambiguous provision. And going on from paragraph 5 to paragraph 51, around and done.
Paragraph 51.
51, Lord Justice Hughes concludes the case by asserting, we're very conscious that the varying, not to say erratic, effect of the existence of two differing statutory regimes applying to the same defendant is to create real and disturbing anomalies between prisoners who ought in fairness to be treated similarly. We are, however, satisfied that any attempt by this court, as in Court of Appeal Criminal Division, to impose a rule designed to cure that problem would not only be wrong in principle given its parliamentary origin, but would also merely throw up other anomalies elsewhere. The court in that case was being asked simply to reverse the order of sentences so that the Court of Appeal decision in this case, the effect of the Court of Appeal decision in this case would be ameliorated by the longer sentence being served last. The court declined properly in our submission so to do. If it be accepted that the paragraph 14 and indeed the other provisions are ambiguous, we've made submissions in writing about the effect of that, and they're submissions of principle, and we say they're not revolutionary submissions. We're not. They are submissions which I submit will be readily accepted. That if they're ambiguous, the court has to adopt a purposive method of construction, and has to, in so doing, look at the context and the history of these provisions. And I've referred to the cases of Inco Europe and Lord Nichols' dicta in that case, and Lord Bingham in Quinterval, as well as some references to Benyon. unless I'm asked to deal with that further, I'll move on from that point. In respect of looking at the parliamentary intention, in respect of these provisions, we say that the decision of the Court of Appeal, the decision the Court of Appeal reached, is one which could not have been intended by Parliament in enacting this scheme or indeed the transitional provisions.
Parliament didn't enact it, the transitional provision.
Well, in terms of the statutory Parent Act provisions, the intent of Parliament is quite clear, to create a scheme and to reenact a scheme, which in situations like this would be 135 days. So in terms of the transitional provisions, we say that it could not have been the intent of the draftsperson, or the minister first of all, or the person drafting it.
Then what, it's subject to negative resolution?
And it was indeed subject to negative resolution. So we say that the intention of these provisions could not have been such as to have reduced the eligibility to HDC in the drastic way that it operates in cases such as this. We say that where, as in all of these cases, the before and after provisions, the Parent Act provisions, provide the same answer, we submit that that would suggest that the transitional provisions would also be intended to achieve as close to that position as was possible, and that where you have serious anomalies, it's likely that the construction of those provisions is wrong. No one, in fact, has suggested otherwise in any of the cases of Heighton or this case in particular, that there was any purpose in the transitional provisions being drafted in such a way as to be construed to cause the anomalies that arise, nor has anyone suggested why sentence calculation should be subject in this arena to the order in which sentences are passed.
Mr. Weatherly, sorry, can you just help? I mean, on the one case, everybody agrees that the new Act doesn't apply. 3 consecutive 9-month sentences, what happens then? What would have been intended under the new legislation if it had been in force?
If the new legislation was in force, the 3 9-month sentences would either have been under section 181 or 183.
They would have to be, would they?
If the full 2003 Act was in force.
There's the only...
Yes. And so...
You can't pass 9-month sentences except under those 2 provisions.
Indeed.
Yep.
I see.
And then they'll all have been aggregated according to the clear provisions of the Act, as they would then have been.
Indeed, they would have been aggregated, both their custodial days and the longest of the licence periods would then have been applied pursuant to subsections 4 and 5, which we've seen haven't been brought into force.
You've been submitting to us why Parliament can't have intended these anomalies. Can you think of any, can you make any submissions about any justification for them? I mean, if we cure what you say is the anomaly, do we create a different sort of anomaly?
No, we say that we've, the reason we produce the examples that we have is that we say that those broadly cover each of the scenarios, and we can't think of any scenario where it doesn't work. So that it provides an answer which gives a consistent result, which is in tune with both the previous historical provisions and the 2003 Act provisions. And we say that...
Secretary of State will no doubt tell us why he resists this appeal so vigorously? There must be some... maybe it's not a legal reason.
Well, that's why he appealed against the judgment in the first place.
Anyway, we'll hear.
Maybe that will be so. And I've addressed the court in respect of our example 3 in respect of the order of sentences, and how it can't be the intention to create a system which is dependent on identifying a lead sentence, but is then not dependent on the order of sentences thereafter. So that deals with parliamentary intent and the intent of the Minister and the draftsperson in our submission. So where the Parent Acts lead to exactly the same result, there must be an overwhelming presumption, we say, that the intention of the transitional provisions should be to reach a position as close as possible to those regimes. Next, we return to the lacuna point, which again we set out in some detail, paragraph 36 of our printed case, and we say this really is the central difficulty for the Court of Appeal decision. The Court of Appeal, with respect, was entirely correct at paragraph 50 for saying that a lacuna in the statutory provisions could not be corrected or filled, particularly in respect to penal provisions, by Secretary of State's policy. But if there is a lacuna, then how are the sentences to be combined? And we say that there isn't a lacuna because our submissions on paragraph 14, we say, are correct. The next submission that I make is in respect of anomaly or absurdity, and again, this is covered at paragraph 38 of our printed case. I don't think it's controversial that the decision in the Court of Appeal leads to all sorts of anomalies, as I've said, both in terms of HDC eligibility and also in terms of licence. And I've already taken, my lords, to paragraph 51 of Round and Done, where these provisions are described, or the effect of them, as erratic and creating of real and disturbing anomalies. We set out, again, at paragraph 38, a list of the difficulties with the Court of Appeal decision, the effect of it. We've been through all, I think, but one of those already, which is the final one of those points, that, in fact, as recognised by the Secretary of State's own policy, one of the anomalies that arises...
Sorry, where are you reading?
Sorry, from my paragraph 38.
38.
Printed case. I've dealt with, I think I've dealt with A, B, C and D already in the course of argument. But in fact, a further anomaly that arises is that it may create a position where there are two concurrent licences. And this is expressly recognised in the Secretary of State's policy, which is at 34. Divided 34. Divided 34. This is the policy document that we briefly looked at earlier, PSI 31 of 2006. And it's paragraph 26, licences. Prisoners will be released on licence. Prisoners will be released on licences in accordance with the Act appropriate to any sentence from which they are being released. This means that prisoners may be released with two licences, a 1991 Act licence and a 2003 Act licence, where, for example, a prisoner is released under the HDC provisions under one Act but there is a further period to be served under supervision under
I
another.
don't understand
Yeah,
that.
nor do I.
I don't understand on the Secretary of State's view how you can be released under the
Well,
provisions of one act.
in the current case, using the current facts, the appellant would have been released on a 2003 Act licence and on an HDC licence under the 1991 Act, because
I see.
the 2003 Act sentence, the custodial period of the 2003 Act sentence would have been 11 months.
Quite.
And she would not have been released at that point because then there was the 5-month sentence. So that would have continued for 2.5 months, minus the HDC on the 5-month term. So at the point at which she was released, she would have been released under a 1991 Act HDC licence, but also under a 2003 Act licence.
Yes, I do see.
And that's, as I say, acknowledged in the Secretary of State's policy document, and we say that simply can't be sensible, that the prisoners are released with 2 separate licences, which potentially could conflict. I'm not suggesting that they're likely to, but they could potentially.
Sorry, who sets the licence conditions?
The licence conditions, I think, are for short-term prisoners, I think, are standard licence conditions, but subject to additional licence conditions, which are then tailored to the individual. I'll be corrected if I'm wrong about that.
No, but I'm sorry, taking our very case, as you rightly say, after 11 months, plus actually a quarter of 5 months, which I think is 38 days, release.
Yes.
And that is release one and the same time, surely,
Yes.
under licence from the 22-month sentence.
Which will then last for the balance of the 22-month sentence.
Exactly.
Yes.
And under HDC, whatever it's called, HDC,
Yes.
for the period of the 38 days.
Yes, indeed.
And that attracts a separate licence?
Yes.
Do different people decide, or what different provisions decide on the terms of these licences, or what?
I don't think it would be a different person. I'm looking to see if I can enlist any help from my learned friends. I think in practice it would be unlikely that the 2 licences would conflict, but they could. In principle, the 2003 Act licence could, for example, have a residency condition at one point, and the HDC licence could have a curfew condition at another location. But my point is more one of principle, that it can't be sensible that provisions lead to an offender being released with 2 licences. And we say that there's a strong presumption against absurdity in statutory construction, and on that basis, the anomalies that are thrown up by the Secretary of State's view, as endorsed by the Court of Appeal, should not be considered to be the appropriate construction of these rather difficult terms. Again, in the printed case, I've referred to sections from Bennion, but also from the case of Edison, and from a Canadian Supreme Court case of Point Clare, which endorses the approach that Bennion has taken. And I've also referred to Buddington, which is a case which in fact involved this very order. I'm not sure it's necessary for me to actually take my lords to those cases, but they illustrate the approach of the court is to avoid a construction of provisions which is absurd.
Yeah, we looked at Buddington and Stellato, didn't we?
Yes, indeed. I'm happy to go to Buddington. It may be useful to go to Buddington in terms of just illustrating this point. It's at divider 14, and it's the judgment of my Lord Judge. Divider 14, the issue revolved around paragraph 23 of the 2005 order about the recall provisions, which is the same provision as under consideration in Stellato. Paragraph 2 of the judgment, the appellant's licence was revoked by the Secretary of State and he was recalled to prison. It's not suggested that this order was unjustified. The contention is that the Secretary of State lacked the power to make it. And the issue was that the claimant thought that they had identified a lacuna in the transitional provisions, which for a small class of prisoners meant that they could not be recalled. And picking up the judgment at paragraph 19, paragraph 23(1) itself has no application to prisoners convicted of offences committed after 4th of April 2005. It is directed to the arrangements for prisoners serving sentences of imprisonment in respect of an offence committed before that date. And the power to recall them after release on licence. Mr. Fitzgerald focuses close attention on the words falls to be released. He argued that it relates to future release. Therefore, paragraph 23(1) had no application to the appellant whose release had taken place before that date. In brief, he no longer felt to be released. And then my Lord Judge goes on in paragraphs 20 to consider the transitional provision and its true meaning. In 21 and 22, considers the claimant's or the appellant's argument that even if his submission might appear strange, it was the inevitable consequence of the actual words used in paragraph 23. The reference made to a purposive approach to legislation in paragraph 22. And then at paragraph 23, our Lord Judge says the difficulty I have with the argument for the appellant is that it produces an absurdity. And at the bottom of 24, such inconsistencies in a system of penal justice designed to produce consistent arrangement for prisoners sentenced under the same statutory regime would be wholly unexpected. And then gives the words used a purposive interpretation. And at 26, this interpretation would do justice to the purpose of the legislation. It would maintain a coherent system of release of prisoners on licence. It would safeguard the public interest by providing sanction against non-compliance by the appellant with his licence condition or in the public interest generally. I'm quite unpersuaded that this interpretation can reasonably be thought to create any injustice for the appellant. And then concludes the judgment by saying that if it were necessary to read in punctuation into
Comma, yes.
Paragraph 23, then my Lord Judge would have done so. And so what we have in my submission in that judgment, coincidentally
Daring
about the
piece
same
of
order,
judicial legislation.
it's a first of all a purposive construction of words which literally might have been taken to mean what the claimant was saying, but moreover was rejecting this literalist approach on the basis that it achieved an absurd result, which plainly it did. And it gave an unwarranted lacuna to a small class of prisoners because of the perhaps slightly loose wording of paragraph 23. So we say that the very clear anomalies that arise both in respect of HDC eligibility and in terms of licence duration should strongly militate against the Court of Appeal construction in this case.
There's some nice comments on what was meant by Homeric exhaustion on
Yes.
the part of the draftsman in paragraph 18. Apparently used the word sentence when he meant offence and anticipated the enactment of the Crime and Disorder Act 1988 by 10 years. I don't know where that appears, but this very body, this very order, is it?
No, it's in the same paragraph.
It's in the same paragraph.
We pick it up in stomata, yeah.
Yes.
Oh yes, there it is, yes.
I don't, with respect, I don't think we should be too critical about the draftsperson here. Looking at this area, it's a very, very difficult area for someone to draft provisions which create the right answer. And looking at, indeed looking at paragraph 14, it may be that the draftsperson started with one position and then we would say the disapplication of the substantive provisions, and then realised that subsections 4 and 5 could not be brought into force because of section 181, and then had to add on the words in parentheses, and then had to add in section 264 to the first part of the paragraph. And it may be that this is an exercise for the draftsman which is well nigh impossible. That may be the difficulty.
Well, when the draftsman has to deal with statutory repeals of repeals, he's in difficulty.
Yes,
And this is a repeal of a repeal.
yes, indeed.
But just application.
Well, it says in the text, repeal.
Does it say that?
So the conclusion from that I would urge this court to draw is that the court has to take a purposive view of these provisions and has to interpret them in such a way, if at all possible, which deals with the anomalies both as to eligibility and also to licence duration. And we say that our solution does in fact create that. And it's one which looks at the provisions in the round in the context of the other provisions and in the context of the history of these provisions both before and after 4th of April 2005. We can see that clearly that the position that we contend for is that was intended by the drafter of the provisions.
Would this, as a matter of interest, have been drafted in the Home Office, or would it have gone to the parliamentary draftsman? We don't know.
I'm afraid I can't answer that. I don't know whether my learned friends can insist on that.
Surely within the Home Office, wouldn't it?
Yes. I don't know.
At that date, yes.
Yes.
In respect to the licence anomaly, the anomaly that arises in this case and in many other cases, as we've illustrated on the examples, and I'll refer back to one of those examples in a moment if I may, is that there is a reduction in licence duration which is completely unwarranted in certain cases, including in this. In both the provisions of the 1991 Act and the 2003 Act, the combining provisions combine not just the custodial periods, but also the licence periods. And as I submitted before, that in this case, the Court of Appeal construction leads to the licence period of sentence 1 being running for the custodial period of sentence 2. And a shortened licence period of 5 months. Well, the clear policy of the 2003 Act was to provide for licence periods which extend to the sentence expiry date. And we can see that clearly not only from section 264, but also from section 249, which we looked at briefly this morning, that with single sentences, the sentence expiry date is now also the licence expiry date. In this case, and in almost all of the cases where this problem arises, the sentences are for offences that had been committed after commencement of the 2003 Act. And therefore, we say that you would expect the licence duration to be to the sentence expiry date and not to an artificially shortened licence period. And of course, that then affects public protection and prevention of crime. And we can illustrate that by the second example at the end of our printed case.
But don't we illustrate it by
this case?
By this case,
Well,
by the alternative formulae given by the Home Office for release dates.
Yes. Yes, well, maybe I don't need to go to that. Yes. So we say, and it's a simple submission, that although our solution leads to lengthened licence durations, that's merited by the policy of the 2003 Act. And the fact that in these cases, mainly in these cases, the offences are committed post the 2003 Act, and therefore one would expect the transitional provisions to have led to licences going to SED rather than to some earlier point. I have made lengthy submissions about paragraphs 14, 19.
I'm sorry, I mean, the reason why it is a shorter period, the licence expires earlier, is simply because you don't include the under 12-month sentence as part of the sentence. And therefore, when you say it continues to the end of the sentence, it does continue to the end of the sentence, but it's to the end of the sentence only insofar as the sentence was over 12 or more.
Well, what we end up with under the Court of Appeal construction is two periods. Sentence 1 with a custodial period and a licence period, and sentence 2 with a separate custodial period and separate licence period.
Right. But non-aggregation, inevitably, if you simply say the licence is to go to the end of the period, is going to be shorter.
The problem arises because with non-aggregation, where you deal with the two systems separately, the problem arises because the second sentence starts during the first sentence. It starts during the licence period of the first sentence, but nevertheless during the first sentence. So you have a concurrent period. So you don't, in fact, aggregate them.
No, but it's the very fact of non-aggregation which means that if you're simply saying the licence extends to the end of the sentence, by definition a non-aggregated sentence, the licence will end earlier than if you'd aggregate
Yes.
them. That's all you're saying.
Yes, but
I mean, of course it follows that of course you're serving part of the second sentence, if you like, during the currency of the first. I mean, that follows obviously if there's non-aggregation.
well, what I'm saying is that the 5-month reduction in this case is set against what would be the position if there was one sentence of 27 months.
Doesn't it follow from two reasons? I mean, firstly, on the Court of Appeal's analysis, the 5-month sentence starts running halfway through the main 22-month sentence. So any question of licence under it is long gone. Isn't that before the end of the 22 months? So there's nothing else left. But even if you ran the 5 months at the end of the 22 months, you could still only have a licence up to the halfway point under the 1991 Act. Even if you took a different view from the Court of Appeal as to how they ran.
Well, the reason I hesitate is that that only applies if you separate the two sentences. If you have aggregation under
of
the
course. No, I mean, on your case, this is all nonsense, and you aggregate, and then you get a licence up to the full end of the 27 months.
Yes, but even under the 1991 Act, you would aggregate the 5 months with the 22 months, so you still end up with a 27 month.
Yes, I see. So it only rises because you're separating the two schemes and applying them separately.
Yes.
Yes.
Although, having said that, not wishing to complicate it too much further, that if it was being dealt with under the 1991 Act, then the licence period would be shorter because the licence ran out at the 3/4 point. But there would then be an at-risk period under section 116. Yes, so it's essentially the same, but it's dealt with in a slightly different fashion. I haven't referred to Stellato. I was going to come to Stellato in respect of 2 points. Firstly, that in respect of Schedule 23, the conclusion of Stellato was that that the mechanism of recall was brought in by paragraph 23, but the substantive provisions of the previous Act were left in place so as not to disadvantage other existing prisoners. I can go just briefly to Stellato. It's at divider 28. And again, same order, paragraph 23. I'm picking up my Lord Brown's judgment at 17. Respondent is a prisoner serving a 10-year sentence for offences committed in June 1998. Reached the 3/4 point. Was entitled to be released unconditionally. And the issue, was he, however, entitled to be released unconditionally, or was he entitled only to release on licence, subject to recall at any time until the end of his sentence? And that arose because of the provisions of paragraph 23 referred to paragraph 23 of the judgment. The new regime came into effect in April 2005. 19 and 23 set out, and then at 25 the question was set out in full, and the issue between the parties was essentially whether paragraph 23 changed the substantive position of pre-Act or pre-2003 Act offenders, or whether it simply imposed the new mechanism for recall but kept the substantive position. And my Lord Brown's conclusion was at 43, picking up the third part of the conclusion, 10 lines from the bottom of the page. Thirdly, the longer one considers the scheme of this part of Schedule 2, the plainer it becomes that paragraph 23 is concerned only with the process of recalling and re-releasing prisoners on licence, and not in any way with the duration of their licences and the point at which they become entitled to unconditional release. Of course, under these transitional arrangements, sections 254 and 256 will be operated in the case of pre-Act offenders in the same way as for every other recalled prisoner, and the Secretary of State and Parole Board will discharge their respective duties and exercise their respective powers as the Act provides. Their powers extend only to the point where the prisoner is entitled to an unconditional release. And as paragraph 19 makes abundantly plain, the rights of pre-Act offenders are in that critical respect saved. Although these provisions are indeed somewhat opaque and ill-drafted, their intended effect is in the last analysis quite clear. The new scheme for recalling and re-releasing prisoners was to come into immediate effect for everyone. No longer was the Parole Board to be primarily responsible for initiating a prisoner's recall by making a recommendation under Section 39. Secretary of State's power being limited by Section 39 to urgent cases where it was impracticable to await a recommendation. Pre-Act offenders were not, however, to be disadvantaged by the new parole regime, in particular with regard to the effective length of their sentences and the period for which they were to be at risk of recall after release on licence, nor is there any of this in the least surprising. And then finally, at 45, the result for which the Secretary of State contends would, in short, be a surprising one, unlikely to have been intended by the legislation, and if it were intended, one would expect it to have been enacted in the clearest of terms. I'll very briefly, if I may, return to Lord Hope's speech in a minute, but before I do, the conclusion of my Lord Brown is that the mechanism, the new mechanism, is brought into force by paragraph 23. But the substantive effect of the new provisions is not, because it's saved for prisoners who are already serving sentences under the 1991 Act. And we say that's important because it shows the scheme of these transitional provisions. And in respect of the issue in this case, which of course isn't recall, what we say is that these provisions are bringing in the new combining mechanism, but then are applying the substantive provisions for the calculation of custodial periods in particular, because they are not, they have not been brought into force. The corresponding provisions have not been brought into force under Section 181, and therefore there is a resonance between the approach taken to recall provisions in paragraphs 23 and indeed with paragraphs 19 and 25 in respect of pre-2003 Act offenders, and the approach that we say is appropriate when considering paragraph 14.
Yes.
And finally, in respect of Stellato, a slightly different point, picking up the speech of Lord Hope, between 4 and 15, which goes through the complex process by which this order is made under the parliamentary procedures, and how it was put before Parliament under the negative resolution. And Lord Hope concludes, at 15, I respectfully agree with Lord Brown that if such a surprising result was intended, it ought to have been enacted in the clearest of terms. In my opinion, this conclusion is greatly strengthened by the method of legislating that was employed in this case. Now, I don't say that this case is on all fours with Stellato in respect of the way it was brought into force, because the anomalies cannot have been intended. But it must be that if the provisions of particularly paragraph 14 were to create a significantly adverse position for a class of prisoners, then it would have been put before Parliament in a different fashion. Finally, I simply return to the appellant's construction. If the Court of Appeal's construction were correct, we say it would involve reading down paragraph 14. It would involve changing the wording of any other sentence to another, wording to any other sentence rather than another such sentence as it currently reads. It may be inelegantly drafted, but looking at it in its context and looking at it purposively, we submit that the way we've approached it is the correct way. It's plainly there to deal with the the non-commencement of sections 181 et sec, and to save the corresponding 1991 Act provisions where necessary. And it disapplies the provisions where it's required to do so. But there is no logic to it also disapplying combining provisions, so that in fact it creates a lacuna in the way that I've attempted to demonstrate in the course of these submissions. It's clear that the draftsman had in mind, in the fact in paragraph 19, schedule 1, that subsections 4 and 5 were not brought into force. It's clear that from that, the reason for that is that the licence lacuna that I referred to earlier, that if they had been brought into force and section 264 had been applied, where all of the sentences were less than 12 months, there would have been a position where, on my Lord Mance's example of 3 9-month sentences, there would have been no licence, whereas under the 1991 Act provisions there would have been a licence. And therefore, it's plain from that we say that paragraph 14 applies to single sentences of less than 12 months. It applies to sentences where all of the sentences are of less than 12 months, but it does not apply, or it does not disapply the combining provisions of the 2003 Act in respect of sentences of more and of less than 12 months for the reasons that I've said. And a strong indicator of that is the fact that our solution leads to a system which works. It works without anomalies, both in respect of licence duration and HDC eligibility. I don't know whether I can assist any further.
No, thank you very much indeed. Mr. Fitzpatrick, have you anything to add?
Nothing large.
No. Yes, Mr. Giffin.
What I propose to tackle the matter the other way round from learning friend and to address my submissions first to the question of what...
Find it on the bench in front, will you? Or have they changed?
Will it work with one?
Oh, they've changed.
I'm grateful. Lords, I shall address first paragraph 14 in the commencement order, the key provision, with a view to...
Before you even do that, say whether the interpretation for which you're contending makes any kind of sense at all.
Well, Lord, I accept two things. First of all, that it does lead to anomalies in the sense that one gets different results from what one would have got on either the 91 Act regime alone or the 2003 Act regime alone. I somewhat balk at the proposition that they are absurdities, because when one looks at the actual result one gets in a particular case, it is not an intrinsically absurd or unreasonable or unacceptable result, but it does introduce differences from what the position would have been under another regime that would have applied at another moment. And secondly, I'm not seeking to tell or persuade your lordships that there is some underlying policy that has deliberately brought about that drafting and those anomalies. So I accept that as a starting point.
Why is the Secretary of State so interested in this result? I mean, I'm sure it isn't just that the draftsman has a particular view, and maybe that's a completely irrelevant thought, but why is the Secretary of State concerned about the result, to defend the result which on its face leads to anomalies?
Well, Lord, 2 points. First of all, the Secretary of State takes the view that the wording of paragraph 14 is clear, and further that the alternative suggested construction of paragraph 14 would require one to be able to identify a custodial period.
Would require what?
I'm sorry, Lord, would require one to be able to identify a custodial period in a manner which the 2003 Act does not permit. Now, your lordships may take a different view, but that is the Secretary of State's position. And the Secretary of State's position, therefore, is that if it is right, that the wording, the language is clear, it should be upheld and applied. Secondly, the Secretary of State recognises, as we set out in the printed case, that the courts below in this and other related litigation have expressed concern about the complexity of the provisions and about anomalies. The Secretary of State's position, as I'm instructed and as set out in the case, is that the Secretary of State takes the view that the right thing is to continue to review the situation and, if necessary, to enact a comprehensive refurbishment of the provisions, for want of a better word, by way of primary legislation.
To put it bluntly, I mean, the Secretary of State has expressed in policy announcements a view which courts have also followed, and there could be presumably some practical consequences.
Well, if your lordship is suggestive, I'm reading between the correct lines, that there could be some financial liability. I don't think that is. I haven't been told that is why we're defending the appeal. And I think, my Lord, it is unlikely, with respect, for this reason, that what it would mean, if we were wrong, would be that some people who had been entitled to the exercise of a discretion in their cases had not received the benefit of the exercise of a discretion. Our normal principles in English law, as my Lord, of course, knows, unlawful administrative action, which is what that would amount to, does not attract a damages remedy. In other words, it's not a case in which a conclusion of false imprisonment follows. So I don't, with respect, think that that would be the consequence of an adverse finding.
I mean, I rather agree, which makes it all the more puzzling as to why the Secretary of State is so intent on this. I mean, you know, his draftsman no doubt knocked up paragraph 14, but I mean, you know, why does he want to go to the stake for how he reads it? Is there any advantage to anybody in actually following your route here?
Well, there is a further point, which is there is an impact on the duration of licenses, and it does make the effects of the construction for which my learned friend contends are different from what one would get either under the 1991 Act read on its own, because, as my learned friend mentioned to you shortly before he sat down, under the 1991 Act, of course, the licence terminates at the 3/4 mark. Secondly, it would be different from what one gets under the Secretary of State's present approach to these provisions. As your lordships have seen, at least in some circumstances, it will produce a longer period on licence than would otherwise be the case. And thirdly, there is also, in some sense at least, although less marked, a difference from what one would get under the fully fledged 2003 Act regime, because if when sentences of less than 12 months are dealt with under that regime, they are to be dealt with under section 181 by the judge setting the custodial period and the licence period. So the fact is that to uphold the appellant's contention in this case is not, as it were, something which removes anomalies with no detriment to anyone. It will mean that some people are on licence where they would not otherwise have been on licence. Of course, how great a detriment that is depends on all manner of things, depending on...
Forgive me interrupting you. How many of them would be out of prison and on licence, which most would regard as an advantage?
Well, that would depend on, amongst other things, how good they were at complying with their licence conditions. But
But when you were submitting that it might produce a longer period of licence, I was wondering what that would be instead of, a longer period of licence. What, instead of a longer period in prison?
Yes, well, your lordship can see, for example, on the facts of this case, in that
We're going back to statement of facts and issues.
statement of facts and
page 3, paragraph 6 and 7.
and issues that Ms. Noone, on her approach, would have been eligible for home detention curfew a little over 3 months earlier than in fact she was, and she would have been subject to a licence which would have continued for a little over 5 months longer.
It's difficult why it isn't precisely 5 months. I mean, why wouldn't it be precisely? Because on the other side's case, you just aggregate and the licence expires at the end of the aggregated sentence instead of the end of the 22-month sentence.
Well, I think the answer to that may be, though I'm not certain, that it's all measured in days, and because February is a short month.
I see, but it's so basically it's 5 months.
Yes, basically it's 5 months. So it is the case that it is not, as it were, well, the Secretary of State's position is indeed, as a matter of policy, under the 2003 Act, to favour licences extending to the end of the sentence, but nonetheless, the fact remains that the intention was that that should be done by bringing the 2003 Act in force to apply to all sentences, including those of less than 12 months, in accordance with the provisions of Section 181 and so on. And so, ultimately, the Secretary of State's position is that it would not be right for us to depart from what the view that has been taken about what the clear words of paragraph 14 mean on a unilateral basis. Now, if your lordships take a different view, of course your lordships take a different view of the meaning of paragraph 14, and so be it. But that is the Secretary of State's stance in these proceedings.
But I mean, you haven't yet, now I apprehend you're not going to try and persuade us that there is any advantage whatever from the Secretary of State's point of view, or indeed anybody else's, in maintaining the solution thus far adopted.
No, my lord, I'm not seeking to persuade your lordships that there is some underlying policy advantage to which this construction of para 14 gives effect. It would make my life, my task, in a sense, more pleasant if I could stand up and say that, but I'm not going to pretend it's so when it isn't.
As far as HDC is concerned, there are two possible policy reasons for its introduction. One is it provides a useful safety lid to prison numbers. The other is it's considered to be a valuable part of rehabilitation. But either way, as a matter of logic, you would think that the amount of time to be potentially available should be proportionate to the overall period of imprisonment and not determined by really a random order in which the sentences were imposed.
Yes, well, my lord, again, as I said at the outset, we accept that this leads to anomalies. In many ways, my lord, this case is a case about how far it is proper for a court to go in improving, as it may see it, the drafting of a piece of legislation.
I mean, I'm a bit puzzled. I mean, I'm not sure if one has to go very far, but I mean, I'm a bit puzzled on what you've said so far, why the Secretary of State, who would appear to recognise that the position we're in is a pretty ludicrous one, no advantages to it. I mean, why didn't he simply, if he thought he was cornered by his own draftsman's paragraph 14, simply amend it?
Well, Lord, the ultimate option of further primary legislation is under consideration. I know, although I'm not party to the detail of the discussion, that there are question marks in the departmental mind about the extent to which it would be within the powers to make delegated legislation conferred by the Act to change the commencement provisions that were made to bring in effect, a 2003 Act regime for less than 12-month sentences by aggregating here in a situation in which the substantive provisions of the 2003 Act were not being brought in for those shorter sentences. My Lord, I'm not making a submission about that one way or the other, but I can say that it's been looked at and doubts have been expressed.
Can I just, before you then, example 5, pages 34 and 35 of the appellant's case, the 18-month sentence, and then this chap in the course of the custodial part of it gets a consecutive month, so that the 130 days potential for home detention curfew, in fact, is eliminated by that.
Yes.
I mean, you accept that that is a true illustration of the consequences of your construction?
I accept that that is a correct example in that sense, yes.
Maybe a bit extreme, but what's not extreme is it's quite common where you have a lengthy sentence to have a short additional consecutive sentence to reflect maybe failed to answer to bail or contempt of court or something like that. Adding that on would have the same overall effect.
Yes, it does.
Yeah. All right. Now persuade us why we've got to uphold Court of Appeal.
Well, my Lords, the basic submission is a pretty short one, which is simply that the wording of paragraph 14 is really clear beyond peradventure. If your Lordships have that open, it's at the appendix at page 113. The construction for the appellant, of course, is that paragraph 14 only applies, first of all, to simple single sentences of less than 12 months, and secondly, to multiple sentences, all of which are of less than 12 months duration. And therefore, that in other situations where there is a combination with one or more sentences of more than 12 months, paragraph 14 does not apply, and everything must be dealt with in accordance with the provisions of the 2003 Act. Therefore, it is at the heart of the case for the appellant that the coming into force of the 2003 Act provisions and the repeal of the 1991 Act provisions is of effect in relation to a sentence of less than 12 months, provided that it is imposed in conjunction with a sentence of more than 12 months. And we say that a legislative stipulation that says that certain provisions are to be of no effect in relation to any sentence of less than 12 months cannot be construed as meaning that those provisions do have effect in relation to some sentences of less than 12 months, which is the effect of the contrary construction.
But it says, it doesn't, any sentence clearly means in the singular because of the bracketed words, which say whether or not such a sentence is imposed to run concurrently or consecutive with another such sentence. So the main part of the wording is talking of a single sentence of imprisonment of less than 12 months, in relation to which, obviously, no problem arises.
Yes. Well, there are 3 points being made, as I understand it, on the other side. as to why paragraph 14 is at least ambiguous. And if I take them in turn, the first, I don't think my learned friend particularly relied on this orally, but it features in, I think, the judgment of Mrs. Justice Dobbs in Highton, is the heading.
On what? I'm so sorry.
The heading of to paragraph 14, my lord, in Highton.
Yes, yes.
The second is the point my Lord Mance has just put to me about the use of the singular, any sentence of imprisonment. And the third is the effect of the words in the brackets. Lords, if I just take those in turn, I accept that it might be said that the heading, so far as it goes, is ambiguous, insofar as it could refer either to prisoners serving sentences of less than 12 months, whether or not in combination with any other kind of sentence, or it might be thought to refer to prisoners who were in prison for less than 12 months. But what is clear is that
nobody suggests the latter, do they?
Well,
what they say is that this is, especially read with the rest of the sentence, just dealing with sentences, whether it's 1 or 5, which are each of less than 12 months.
Yes, well, Lord, with respect, absolutely, which is why one can readily see that any ambiguity there might be in the heading does not, in fact, point to the other construction. Lord, so far as the singular word sentence in the phrase any sentence of imprisonment is concerned, in my submission there are really two answers to that. The first and primary one is that from the point of view of the construction we advance, it is not necessary for the singular to include the plural, because saying that the legislative changes are of no effect in relation to any sentence of less than 12 months is the result we are seeking. On our construction, you take any given sentence which is of less than 12 months and you apply the 1991 Act rules to it accordingly. On my learned friend's construction, you take a sentence of less than 12 months, even if there is only one such sentence. So suppose the simple case where you have one 8-month sentence and one 18-month sentence. It is my learned friend's construction that the 2003 Act rules get applied to that 8-month sentence through a process of aggregation. So whether it is singular or whether it is plural, it is in my submission inescapable that on the appellant's construction, the 2003 Act provisions have an effect upon that sentence. That is the whole purpose and object of the argument. So the mere fact that the singular person is used at that point in the drafting takes one nowhere and certainly doesn't assist the appellant. We know in any event that paragraph 14 clearly does apply to cases where there is more than one sentence in issue, because it is common ground that if you have, again to take my Lord Mance's example, 3 9-month sentences, that paragraph 14 would operate so as to keep them entirely within the province of the 1991 Act. So,
but isn't it rather bizarre to clarify that by the parentheses if you're failing to clarify what seems to me to be an altogether less likely thought, namely that it applies when you combine it with a more than 6-month sentence?
Well, that does then take one to the parentheses. And first of all, we agree with the appellant that the words "another such sentence" refer back to the phrase "any sentence of imprisonment of less than 12 months." We think with respect that that is clear and inescapable, just as a matter of syntax. But what my learned friend then wants to go on to say is that because the words in brackets only refer to consecutive and concurrent sentences of less than 12 months, that therefore demonstrates that paragraph 14 has no application where there is a consecutive sentence which is of more than 12 months. And unless that conclusion can be drawn from the words in brackets, then in my submission there is simply no hook whatever in the language of the provision upon which the appellant's construction argument can be hung. But we say, well, first of all, it would be an astonishingly oblique drafting technique to put words in brackets saying whether or not another short sentence is imposed as a means of limiting the otherwise all-embracing words.
But it's not limiting them, it's explaining them. It is showing that you're not just dealing with a situation where you've got one sentence of imprisonment of less than 12 months and nothing else in the arena. That clearly is just a 1991 situation. Yes. So that's covered by the words or not. So there's no other sentence. And then this provision is also to apply in situations covered by the word whether, namely where there is either concurrently or consecutively another 12-month sentence. And those are the situations in which it is to apply.
Well, what is...
I mean, that makes perfect sense, as has been pointed out, because as soon as you get a sentence of more than 12 months, then you've got operative provisions which you would otherwise be running into conflict with if you had this paragraph applying to mixed sentences.
Well, Maud says, and we with respect agree, that when you see the introductory words whether or not, that indicates beyond dispute that those must be words of explanation or clarification and not words of limitation.
Yes, and what they're explaining is two possible situations in which the earlier phrase may apply. And one is where there is no other sentence in the arena at all. So you've just got one single sentence of imprisonment of less than 12 months. And the other situation is where you have another sentence or sentences of less than 12 months, which either run concurrently or consecutively. And that's the explanation.
In our submission, what we would respectfully characterise as the fallacy in that reasoning is that that is then operating as words of limitation by saying that the only situation, as it were, left outside the brackets, or the only situation covered by the words or not, is where you have a single sentence of imprisonment of less than 12 months. But that's not the position. In my submission, it's helpful to try and identify what is the potential doubt that these words are seeking to clarify. And it is this. Suppose one had a situation of 3 6-month sentences, consecutive, so that they add up to 18 months. If the paragraph simply stopped at the words of no effect in relation to any sentence of imprisonment of less than 12 months, one can imagine the question being asked, well, in total, this individual has been sentenced to more than 12 months, 18 altogether, albeit any one sentence is of less than 12 months, each of 6. How is the paragraph intended to apply in such a case? And the words in brackets supply an answer to that. Even if you have other sentences of less than 12 months, however many there may be, whether they're concurrent or consecutive, the basic proposition that sentences of less than 12 months remain governed by the 1991 Act remains unchanged. That is what the words in brackets do. They perceive a potential understandable query and answer it. But what one cannot deduce from saying that, one can paraphrase the words in brackets in this way, whether or not. They say, in effect, it makes no difference whether you add on, whether you've got other short sentences in play. That doesn't matter. Telling the reader that it makes no difference whether you have got other short sentences in play can make no possible difference in answering the question, what effect does it have if you have one or more long sentences in play, if one uses long sentence as a shorthand for more than 12 months? In order to answer that question, which is the pertinent question in this appeal, you don't need the brackets, they're not relevant to it. You are simply left still with the proposition that the legislative changes are of no effect in relation to any sentence of imprisonment of less than 12 months. It does not need to say whether or not such a sentence is imposed to run concurrently or consecutively with a sentence of more than 12 months, because no one could possibly have thought, if the words without the brackets had stood alone, that the addition of such a longer sentence made that same difference.
Mr. Giffen, just tell me, if a sentence is passed of 18 months and 9 months concurrent,
Yes.
how is the 9 months concurrently dealt with? Is that dealt with under the 1991 Act as a separate sentence?
On the Secretary of State's construction?
Yeah.
Yes, Maud.
How does that work? I was focusing on exactly the same question,
Yeah.
the significance of the reference to concurrently. And I was just trying to work out.
What's the effect of that?
Yes.
Well, that takes one back to section 263 of the 2000 and I'm sorry, Maud, it doesn't at all, because we're on yes, the The 18-month sentence will be dealt with under the 2003 Act. Section 263 will not be in play because it won't apply to the sentence of 9 months. Therefore, one will simply work out the release date for the 18th month sentence alone. So far as the 9-month sentence is concerned, the release date for that will fall to be worked out under the 1991 Act. It will not fall to be single-termed with the 18-month sentence. The result will be that at the time when the individual would fall to be released under the 1991 Act from the shorter sentence, the longer concurrent sentence will still be in force and he will still be detained pursuant to that sentence. I think is the answer.
I can't actually see how the shorter sentence would make any difference.
Lord, I think it
either
wouldn't
way.
ultimately.
What?
Lord, I think your lordship's right ultimately, but that's the way. Indeed, I mean, if one had, under any regime, a short sentence concurrent with a longer one, it will.
You just, where
It's effectively
it
subsumed.
would have made a difference is if 264(4) had been in force, because then you are looking at aggregating license periods.
Yes. Lord, with respect, that is right. And
Yes.
my learned friend sought to suggest in the course of his submissions that one could, as I understood it, one could explain paragraph 14 and the approach taken there as a function of concerns about how section 264 4 and 5 would otherwise create what I think he called a licence lacuna. But we submit that is really just to introduce an unnecessary overcomplication. 264, 4 and 5 have not been brought into effect at all for the same reason that the other provisions in the 2003 Act that only deal with sentences of less than 12 months have not been brought into force, simply because the 2003 Act has not been implemented in relation to those shorter sentences. So they're not being brought in because in policy terms there is as yet no call to bring them in. Therefore, any question of having to disapply them or worry about their effects simply doesn't arise because they're just not, as it were, not there on the statute book. By contrast, if one takes section 264, subsection 3, which, as Lord Brown pointed out in argument this morning, refers to where any of the terms of imprisonment is a term of 12 months or more, and therefore contemplates, as a matter of the primary legislation, a mixture of longer and shorter. That, of course, is brought into force because you need it even where you're only dealing with terms of more than 12 months. But what you then do, by paragraph 14, is disapply it to the terms of less than 12 months, and that's what paragraph 14 does. So,
well, that does it? I mean, that's the question.
Well,
does it apply? Because, I mean, on the face of it, 2643 applies to a 9 and 18-month sentence.
Subject to paragraph 14.
Quite. So
yes.
It all depends on how you construe paragraph.
Oh, my lord, certainly. But what we can say is that our approach involves none of these complications. It simply involves treating paragraph 14 as meaning what it says, that the provisions in question and the repeals in question are of no effect in relation to any less than 12-month sentence. And then that deals quite straightforwardly with any issues about section 264. It is only if one introduces the more elaborate construction of paragraph 14, for which my learned friend is contending, that one runs into issues of those kind.
And your submission, if I understand it correctly, is that to do that would be to go directly contrary to the words no effect in paragraph 14, because it would be modifying those words.
Lord, exactly. The words no effect and the word any. And that really is, whatever merit, if any, the submission has, sophistication is not amongst them. It is as simple as that. That the plain words of the provision should be applied. And Lord, I suppose I'm really invite your lordships to ask yourselves this question, standing all the issues about anomalies that have been identified, in a context in which complaint has frequently been made about obscurity of provisions, is it the right approach, in the name of addressing anomalies, to be adopting a construction of paragraph 14, which is, as we would submit, the very opposite of what any ordinary reader would naturally think that it meant? Well, that is really the point on what paragraph 14 actually says. I need to come back to the assistance that my learned friend seeks to derive from paragraphs 19 and 25, but on 14, that is really the point. The other consideration that weighed heavily with the Court of Appeal in rejecting the appellant's construction was the question of the custodial period and how you get that for the shorter sentence in a case of this nature. And, my lords, if I can just, your lordships have seen the provisions, but if I can just remind your lordships of them extremely briefly. At appendix page 85, there is section 244 of the 2003 Act, which is the operative provision in the sense that it says when there is a duty to release, and it all hinges on the requisite...
I'm sorry, what's the page again?
I'm sorry, my lord, it's...
85.
85 of the appendix. And it all hinges on the requisite custodial period, which is a concept precisely defined by 2443. And one sees in 2443B, my lord, that in relation to a person serving a sentence of imprisonment term of less than 12 months, other than an intermittent custody order one, it's the custodial period within the meaning of section 181. Now, that little b has not been brought into force because the Act is not in force in relation to sentences of less than 12 months. And then one has D, which would be the directly relevant one here, in relation to a person serving 2 or more concurrent or consecutive sentences, none of them intermittent custody orders, the period determined under sections 2632 and 2642. And as my learned friend showed you, lordships, that takes one in to section 2642, which is on page 96 of the appendix. And nothing requires the Secretary of State to release until he's served a period equal to the aggregate of the length of the custodial periods in relation to each of the terms of imprisonment, and thence into the definition in section 264 sub 6. And it is common ground that it is not possible to operate 264 6A little 3 in relation to a term of less than 12 months complying with section 181, the custodial period as defined by subsection 3A of that section. That can't be operated because section 181 has not been brought into force. And therefore, it's accepted that you cannot point to a provision in section 264, or indeed in the 2003 Act anywhere, which tells one what the custodial period is for the purposes of operating Section 244. That is why my learned friend submits that Section 2646 is not a comprehensive definition of custodial period, and that it is possible for the custodial period for the purposes of Section 2642 to be identified in some other way, otherwise than by reference to subsection 6. My Lord, we submit that if one looks at Section 264, that is an implausible proposition. It is quite clear that Section 2642 is contemplating a precise calculation based upon a specific concept, and 2646 does indeed adopt the language that in this section, custodial period means is in effect the phrase that appears in each of 1, little 2 and little 3, although the word means appears in each of those subparagraphs and the words custodial period before them. One would therefore expect that that was going to give the answer to what the custodial period was. My learned friend says, but you can tell it is not exhaustive or comprehensive because it is possible to point to cases where Section 2646 does not give you the answer. However, the only instance to which the appellant is able to point is that of the intermittent custody period. And it is quite true that the intermittent custody period is the one case in which the 2003 Act contemplates a term of less than 12 months that does not comply with Section 181. It is also true that when the 2003 Act was first put on the statute book, it did not make express provision for the position in relation to intermittent custody orders. But as my lords see, if you're looking at the updated version of the provision, 2641C says that the Section 264 only applies where none of the terms in question is a term to which an intermittent custody order relates. And intermittent custody orders, consecutive terms, are now dealt with by Section 264 capital A. So by the time the commencement order, which the court is now seeking to construe, was made in 2005, March 2005 to be precise, the Domestic Violence, Crime and Victims Act of 2004 had already taken steps to fill that lacuna in relation to intermittent custody orders. Whether originally that was simply a drafting oversight or whether it didn't occur to the draftsman at the time that intermittent custody orders would lend themselves to consecutive provision, perhaps matters not. What one can see, if one is trying to construe the commencement order by reference to the primary legislation under which it was made, by the time the commencement order was made, steps had manifestly been taken precisely in order to make sure that Section 2646 did deal comprehensively with the situations in which you might have to identify a custodial period. Lords, I'm in your lordship's hands as to
I think we'll adjourn now.